When we meet clients for the first time, almost invariably the first question asked is how much my case is worth. Any lawyer that tells you what your case is worth at your first meeting isn't giving you the straight shoot. They're not being honest. But unfortunately, a lot of clients respond to a lawyer sitting at their table, signing up a client and talking about the facts of their case by saying your case is worth millions of dollars, your case is worth a couple $100,000, your case is worth X. But lawyers aren't being honest when they're doing that, and we don't do that. In fact, we make it very clear to the attorneys that work in our office, especially, that you can't tell a client what their case is worth at the outset. We don't know if the client has some kind of record in the past. We don't know what their work history is. We don't know what their lost wages will be. We don't know how the injury is going to affect their long-term ability to earn, whether they're going to have diminished earnings capacity. We don't know how the investigation and working up the case is going to lead to those numbers, and or whether there's any kind of contributory negligence or comparative negligence on the part of the client. So any lawyer that sits at your table or in their office and sits across from you and tells you, sign with me, your case is worth millions of dollars, or your case is worth X, they're not being straightforward with you. They're not being honest. We tell our clients and give our clients all the information they need to make an informed decision. It's very important that we don't pressure our clients. I wouldn't want to be in a position where I'm sitting across from somebody who's got some specialized knowledge that I need assistance from, and I don't want them to lie to me. I want honest, straightforward information, good or bad, so I can make a reasoned, informed decision. So we're very strict about that. When a client does ask me that, I explain that to them. There are many components to damages in a person's case. They could have diminished earnings capacity. They could have liens on their case. They could have future and past medical treatment that isn't contemplated when you're first meeting the client. We don't know how the injury is going to develop. Is there going to be arthritis which is common after a traumatic injury of some sort? We don't know if that person's going to be able to go back to work. There's so many different nuances when you're determining the damages of a case that it's impossible to give a real number to a client. The only thing that person's doing is lying to get that person to sign a retainer form and to hire them as their attorneys. We don't do that. I don't like to ever pressure a client, ever. Whether we're making a trip 100 miles to meet the client and sit down with them, we never lose sight of the fact that that's a very important decision, hiring a lawyer, and that client deserves every bit of information they need to make an informed decision. So they should know every aspect before they sign that document. And it's worked out very well for us. People respond to honesty, and that's been good for us. So I think just very simply, it's important that you're very honest with your client. It's good for the relationship. It's good for the development of the case, and it's good for making sure that you're not surprised with anything by the defendants, because the client feels comfortable with you and explaining everything they need to explain to develop your case.